Thank you so much, everyone, for being here. My name is Pamela Beets, and I am the director of the Access to Justice program at the Utah State Bar. We appreciate you coming to our Crimmigration CLE. We have some great presenters here today. The first who's going to speak is Katie Rain. She's the executive director at No More a Stranger Foundation. And this is a nonprofit located down south in the Provo-Orem area, and they do immigration. She's going to talk to you about some opportunities to volunteer with their organization. And then we're going to hear from Dan Black. He's an attorney with Stoll Crake. He specializes in immigration law and criminal defense. He has about 10 years of experience. He is a grad of S.J. Quinney Law, and he worked with Salt Lake Legal Defenders as an intern, and then also with the Salt Lake Immigration Court. So he's going to be highlighting the concerns when criminal law and immigration law intersect and give some instruction about how to prevent these issues in practice. So let's go ahead and get started. Katie, let's hear from you first.
Thanks, Pamela. It's great to be here and to have this opportunity to talk for just a minute or two about the No More a Stranger Foundation, or No MOS, and the volunteer opportunities that we have in No MOS. The No More a Stranger Foundation takes immigration cases, and we represent individuals mainly on green card applications through adjustment of status, citizenship applications, and then we do a lot of humanitarian types of cases, including asylum and temporary protected status, as well as U and T visas for victims of crime and human trafficking. Our model at the No More a Stranger Foundation is to have attorneys come in and volunteer for 2 hours on a Thursday evening or a Tuesday evening. And I see some names of our volunteers on here. So some of you have already come to No MOS and been involved, but the rest of you are also invited to come. We have clinics in Salt Lake, up in Logan, and then in Rexburg, Idaho. And attorneys can come and help work on a piece of a case. No MOS staff attorneys review and vet and sign off on all of our No MOS cases. So we're not asking you to come and take on a case or enter an appearance or even give your contact info out to clients. You will only be working with clients during the 2 hours that you are there at the clinic. And you may help someone fill out forms, sit down and fill out an application, or put together a declaration, help them get all of the facts written down for a declaration to support their case, or work with them to gather the evidence documents that they need for a case. All of our training is provided on site. We give detailed instructions, and you don't have to have any background in immigration law or criminal law. I think our next presenter is going to go into a lot of detail, which is great. There's a huge need for helping individuals with this complicated criminal background. The cases that we take at No MOS would be a great place to come and just get some experience and exposure to immigration law. Again, because all of the cases are vetted and approved by No MOS staff attorneys, you're really just helping with one piece of a case, and then you're not producing any final work product. So hopefully that takes a lot of the stress of volunteering off. You can just come either on Tuesday nights or Thursday nights from 5 to 7. We're up in Salt Lake, we're up in Logan and Rexburg every Thursday. So if you're interested in volunteering, you can get the addresses and sign up on our website, and it will be sent out with the attendance certificate after this meeting, but it's NOMAS, NOMAS, legal, legal.org. So you can go on there and find us and find more information about those opportunities to volunteer. So we would love to see any of you who may be interested in our No MOS clinics in the next few months.
Thank you so much, Katie. Also, if you are interested in taking full representation immigration cases, there is also an opportunity to volunteer with Catholic Community Services, and we'll send out more information about that along with the certificate as well. So now we're going to turn the time over to Dan. If during the presentation you think of questions that you would like to ask, feel free to put them in the chat and we'll address them either during the session if it seems appropriate, or we'll wait till the end and wrap up then. Thank you so much.
Okay, hello everyone, good afternoon. Like I said, my name is Dan Black. I'm a criminal defense and immigration attorney at Stoll Crake. I'm a regional partner because we have an office here in Ogden, and I run this office in Ogden, but I was down in the Salt Lake office that's on State Street for 8 years, and I've been doing this for about 10 years. And we are the largest immigration law firm in the state of Utah. We have over a dozen attorneys, and we do immigration, criminal defense, family law, kind of a one-stop shop for folks who come in, if they've got a DUI that they need to be represented on, they're not a citizen, and then also they want to get a divorce or something. We handle all three of them. So, but we, as a firm, we also have public defender contracts with several cities, Common Heights, Holiday, Draper, Midvale, Lehigh, Taylorsville, South Salt Lake, South Jordan. We have the conflict contract with Larson, Nash & Larson, who also have several city contracts. We have a conflict contract with LDA, and also the contract with LDA for their crimmigration consultations. So if they're representing a non-citizen and needed to get some immigration consultation done before accepting a plea deal, they reach out to us, and that's mainly with my partner, Adam Craik. And we are in immigration court quite a bit, at USCIS quite a bit. We do almost every area of immigration law. And this particular area of crimmigration, we are calling it, right? The intersection between immigration law and criminal law. We specialize in that because of our nature of having the public defender contracts and taking on a lot of private criminal cases and the immigration work that we do. So it's an area that it seems to be constantly changing. There's lots of different areas of the law that impact it, both state criminal laws, but also the Attorney General, the Board of Immigration Appeals, circuit courts, the Supreme Court, all when they make decisions, they can impact this specific area. So it's constantly changing, which is why having an immigration attorney, or better yet, a crimmigration attorney phone number that you can call and ask questions to is always helpful if you are representing non-citizen clients in criminal cases. And so that's our topic today. And I've got a PowerPoint. I'm told that they're going to turn it into a PDF and make it available later. And this is also being recorded so that people can watch it also later, or if they missed today. But I'm just going to go through, and first of all, I wanted to talk about, let me see if I can get to the next slide. There we go. Why this is important. In 2010, the U.S. Supreme Court came down with a decision, Padilla v. Kentucky, which changed the responsibilities of criminal defense attorneys from that point forward, basically saying that failure to advise non-citizen defendants regarding the potential immigration consequences of a conviction prior to them pleading guilty or no contest is essentially ineffective assistance of counsel, and the basis for challenging that conviction. And So what that does is that puts the responsibility on criminal defense attorneys when they're representing a non-citizen to make sure that before they plead guilty or no contest, that they will understand the potential immigration consequences of that guilty plea. So, and it was interesting, the Supreme Court found that deportation, even though it's a collateral consequence to what's happening in the criminal court, it is something that is so severe that defendants must be warned of that possibility prior to entering a knowing plea. And so we actually handle a lot of these types of cases where folks come in, they have a criminal conviction after 2010, and they were not advised properly of the immigration consequences prior to them pleading guilty. And so misadvice or failure to advise are grounds for setting aside a conviction if you can show prejudice. And there's almost always prejudice when there's a conviction for a deportable offense or an inadmissible offense. And that person later on finds out, well, now I no longer qualify to get a green card, or now I'm in deportation proceedings for something. And so there is some forms of post-conviction relief that I'll talk about at the end. So, Padilla, unfortunately, is not retroactive. It's basically from 2010 on, fortunately or unfortunately, depending on which side you're looking at. But Padilla really puts that responsibility on criminal defense attorneys, whether or not they have immigration experience or not. So how does that look? Well, the best practice is to refer them to an immigration attorney, or especially if possible, a crimmigration attorney, for a consultation about a potential plea deal before accepting a deal. And it is possible for a criminal defense attorney just to say, hey, you're not a citizen. This could result in deportation, right? And that's language that's in a lot of the plea forms. But in my opinion, the best practice is to actually have them either sit down with an immigration or crimmigration attorney, or you yourself as the defense attorney consult with one of us, so that you can properly advise your client what is this actually going to do with your immigration status prior to them pleading guilty, so that they can make a knowing and voluntary plea. And like I said at the beginning, immigration laws, interpretations are constantly changing, and there's always exceptions to the rule, and there's always, it's a case-by-case basis. What will a conviction do for that particular defendant? And so having information about lots of different aspects is useful. Not just here's the offer and the person's not a citizen. There's a lot more that goes into that kind of an analysis. For example, for certain benefits like TPS, which is temporary protected status, or DACA, deferred action for childhood arrivals, even some misdemeanors can disqualify them, even if they are not deportable offenses. And sometimes more than just pleading to a different charge or pleading to a charge that doesn't have immigration consequences might not be enough. Maybe there needs to be an amendment of the information, or maybe we need to scrub the probable cause statement of any mention of a controlled substance, a particular controlled substance, for example. I mean, there's different strategies that can be employed to mitigate the immigration consequences of a guilty plea. And some immigration benefits are discretionary. And even sometimes a police report can be considered, even if charges are dismissed or a plea is reduced to a different charge. So, there's lots of different things, and we're going to talk about many of those, but we can't possibly talk about all of them here. And so if you don't know an immigration attorney or a crimmigration attorney, find one in your jurisdiction, or at least in the state of Utah, who you can reach out to or refer your clients to. So what to ask? And this first question, if you get nothing more out of this whole CLE today, the most important thing I can tell you is for every single defendant that you are representing, regardless, you know, regardless of what the crime is, regardless of, you know, who they are, or if they have an accent or not, or whatever, you should be asking, are you a U.S. citizen? That's just part of my regular practice. It's actually part of most plea forms when you're going over the plea form with your client before accepting a deal. I just ask them, are you a U.S. citizen? Right? If they say yes, great. I mean, you've done your due diligence as far as making sure to advise them about any immigration consequences. But if they say, no, I'm not a U.S. citizen, right, then that should trigger a series of actions. For example, you might want to get some more information from them. What is your immigration status now? You know, what country are you from? When did you last enter the United States? Did you come in on a visa? What type of visa? Do you have a green card? These are questions, you don't have to ask the remainder of these questions, but these are questions that if you do ask them and you gather that information, it'll be helpful when you do speak on their behalf with a crimmigration attorney, or when you send them to an immigration attorney, we will ask those questions because we need to find out their background, find out if they have been deported before, find out about family members, if they have any U.S. citizen or permanent resident family members, like specifically parents, spouses, or children are the ones that are helpful. You know, cousins, aunts, uncles, those don't give you any benefit. But parents, spouses, or children, have they ever been in front of a different judge before, right? You're trying to get a handle on their criminal history if they have any. And if they're working with an immigration attorney already, right? Maybe they're already in the process. And so you can refer them to that attorney specifically to go and talk about this. But the most important thing is finding out, are they a U.S. citizen or not, right? Because if they're not, then Padilla comes into play and you're required to advise them properly, right? Or not misadvise them about the potential immigration consequences of taking any particular deal. So when we're talking about the immigration consequences of a guilty plea, we're actually referring more to a conviction under the Immigration and Nationality Act, which is Title 8 of the U.S. Code. The only criminal activity that is that brings about negative immigration consequences is when those become a conviction, right? So just having the charges, just having an arrest, those don't necessarily trigger deportability or inadmissibility, which are some terms I'll talk about in a minute. But once there is a conviction, that will follow the non-citizen for the rest of their life, essentially. Expungements, state expungements are not recognized by federal immigration law. And so doing an expungement is not going to erase the conviction for immigration purposes. It will stay there, and it's usually tied to their fingerprints. So if they have a conviction and they've been fingerprinted, immigration will know about it, and it will carry. What is a conviction? A conviction is where you have to have two things. Okay, you have to have a finding of guilt, and you have to have a punishment or restriction on liberty. Okay, and so a plea in abeyance is a conviction for immigration purposes. Why? Because there is a plea, even if it's not entered by the criminal court as a conviction for that court, but there is an admission of guilt, either a guilty plea or a no contest plea. Those are the same for immigration. They're not treated any differently, but there is a plea that's entered for a plea in abeyance, and then there are some conditions put upon them, some restraint of liberty, some punishment, some, to pay a fine. So paying a fine is a punishment. Doing classes is a punishment. Being on probation is a punishment. So any condition that follows the plea will turn that into a conviction. Even if the plea in abeyance is successfully completed at the end and the charge is dismissed and the judge says your guilty plea has been withdrawn and the charge dismissed, Doesn't matter. For immigration purposes, it is still a conviction. And so oftentimes, when the offer for one of my clients is a plea in abeyance, for example, to a domestic violence charge, I might counter and say, well, because of their immigration status, a plea in abeyance is really not going to help them, right? It's not going to do the same thing for them like it would for a U.S. citizen. And so I might counter and say, instead of a plea in abeyance, maybe we could do a straight plea, a guilty plea to a lower charge, like a disorderly conduct, non-DV or something like that, because that is more helpful to my client having a conviction for a lesser offense that doesn't carry immigration consequences, as opposed to doing a plea in abeyance to an offense that does carry immigration consequences. Okay, so a plea in abeyance is a conviction for immigration. Guilty and mentally ill or an Alford plea, those are the same. Those are treated the same as just a guilty plea. Bail forfeiture is not an admission of guilt. If they just pay a ticket, right, without going in front of the judge, then it's not a conviction. If they are able to get out of the admission of guilt part of it, it won't ever end up as a conviction. Diversion agreements, similarly, are typically not considered convictions in the state of Utah because you can't enter the diversion agreement without ever entering a plea. And so diversion agreements are typically a good way to go to avoid a conviction, okay? Now, there is an analytical framework for evaluating convictions. I'm not going to go into this because, this can take years just to understand. The categorical approach, the modified categorical approach, this is a very case-specific, fact-intensive legal analysis of statutes and immigration law. But in general, when you are determining whether a particular conviction under a state statute will carry immigration consequences, you apply the categorical approach, where you don't actually look at the particular facts of the case, but instead you compare the language in the state statute with the generic federal definition of that generic crime, and then you try and see if there is a categorical mismatch or a categorical match. If there is a categorical match, then this is a crime that carries immigration consequences because it's recognized by the under federal law as a crime. But if there is a categorical mismatch, if they don't line up, then you have an argument, and we make these arguments all the time in immigration court before the immigration judge, that this particular crime under this particular state statute is not a crime under the federal statute because they just don't match up, and so it does not carry immigration consequences. If they do match up, then you go on to a second step of the modified categorical approach. You try and determine whether the statute is divisible, what are elements, what are means. Like I said, I don't expect you to, first of all, understand what I'm talking about, but second of all, have to do this with your client. That's why you want to refer them to a crimmigration attorney who can do that analysis and determine whether or not this really is going to carry immigration consequences or not. And we've done that at our firm through most of the Utah code, determined which types of criminal statutes in the state of Utah would carry immigration consequences, which ones are arguably not, and so forth. But I'm going to move on to have you know what to look for, okay? Now, and I've used these two words before, deportable and inadmissible. There are convictions which can make someone deportable, and there are convictions which make someone inadmissible, and there are convictions that do both, and there are convictions that do neither, right? But really quick, when someone is deportable, that's someone who's inside the United States and can be deported. When someone is inadmissible, that's someone who is outside the United States and trying to come into the United States to get some, to be admitted into the United States. If they're inadmissible, they can't come in. But also for folks who are inside the United States and they're trying to get some kind of a legal status or some kind of immigration benefit, They also need to be admissible, even if they're in the United States, they're already admitted. And if they have a specific criminal conviction that is deemed inadmissible, an inadmissibility offense, then they can no longer qualify for that benefit unless they can get a waiver, and there's some waivers for certain crimes. So what I'm going to talk about first is what types of crimes make someone deportable from the United States, okay? And something to look out for in general are crimes involving moral turpitude, or CIMTs, we refer to them, okay? The CIMT is something that is referenced in the INA, the Immigration Nationality Act, but not necessarily defined. It's defined by case law as any crime, and this is just in general, any crime that is base, vile, or depraved, and that violates the accepted morals of society. So you tell me what that means. But generally, it has to be a crime that has a mens rea of knowing or intentional, or sometimes reckless, depending on, and accompanied by reprehensible conduct, okay? And so, interestingly enough, if you plead guilty to a negligent crime, right, that has a negligent mens rea, generally that is not a CIMT, okay, because it doesn't carry the base, vile, or depraved mental state that's necessary, okay? Strict liability offenses are also, interestingly, not CIMTs. For example, a DUI, and this might seem shocking, a DUI is not a CIMT. A DUI is a strict liability offense, and so does not carry that inadmissibility or deportability immigration consequence, unless there are, I mean, and we'll get into this, but if you have a third-degree felony DUI or a DUI with certain aggravating factors, that could carry some immigration consequences. But in general, Class B DUI, strict liability offense, it's not a CIMT, and depending on the administration, they might be able to even go to jail and do their time for a DUI and not be picked up by ICE. And so, I mean, but a DUI is still something you probably want to refer to an immigration or crimmigration attorney for, the immigration consequences, because it can affect, DACA, it can affect TPS, things like that. Some of the discretionary benefits, it will delay someone's ability to get citizenship. But strictly speaking, because it's a strict liability offense, it doesn't carry any particular mens rea, it's not a CIMT, okay? What is a CIMT? Well, examples of CIMTs include theft, fraud, false info to a police officer, certain assault offenses that, like assault against a pregnant person, things like that. But there are alternatives, and here's your first tip when representing somebody that's a non-citizen and that's been charged with theft. A good alternative is wrongful appropriation, okay? Wrongful appropriation, although it is a subset of theft in the statute, it does not carry it is not a CIMT. It doesn't carry the same immigration consequences. False info to a police officer is a CIMT, but failure to disclose your identity to a police officer is not a CIMT, right? Because, I mean, you can imagine giving false info, right? That fraud or deceit aspect of it, but simply refusing or failing to disclose your identity doesn't have the same base, vile, or depraved mens rea. Simple assault, and we'll talk about this a little bit later. Simple assault is generally not a CIMT, and at least here in Utah, it's not a CIMT. And even DV assault recently was found by the U.S. Supreme Court to not be a crime of violence and not carry these dire immigration consequences. But we'll talk about that a little bit later too. So one CIMT committed within 5 years of their entry into the United States, and that is punishable by 1 year or more, will make them deportable. Okay, so if it is a theft by receiving stolen property as a third-degree felony, that's a CIMT, and depending on when they entered the United States and when it was committed, and because it's punishable by 0 to 5 in the Utah State Prison, that's a deportable offense, right? 2 CIMTs that are from different incidents, not in the same case, after they are admitted, makes also a non-citizen deportable from the United States. So a CIMT can carry very dire immigration consequences, and so if you have a non-citizen before accepting a guilty plea or a plea to something else, when they're discussing that with an immigration attorney or crimmigration attorney, you want to avoid CIMTs, right? And see if there's another alternative that will not carry those immigration consequences. So CIMTs, we want to avoid those generally, and you definitely want to avoid aggravated felonies. Okay, an aggravated felony is actually a term of art that's used in the INA, Immigration Nationality Act, but it is a term of art, and it is, an aggravated felony does not have to be aggravated or a felony. It can be just a misdemeanor. And so there's lots of different things. They actually have a list in the INA of what is an aggravated felony and what is not. And so it's literally a list of dozens of common law crimes like burglary, perjury, others that just fall under federal statutes, and those are deemed aggravated felonies. And if they have a conviction for an aggravated felony, it carries severe immigration consequences. They are deportable. In many instances, it will keep them from being able to qualify for certain relief from deportation. It will make them mandatorily detainable, so they can't get an immigration bond. I mean, it carries a lot of dire consequences, right? Both federal and state offenses can be aggravated felonies, and attempt or conspiracy to commit an aggravated felony is still an aggravated felony. And so here's my next tip. Don't use attempt language when you are pleading out a non-citizen. Going back to CIMTs, if someone is attempting to commit DV assault, for example, or if they're attempting to commit child abuse, then immigration authorities are going to look at that and say, well, you have the intent to do that. That's why you were by attempting to do that, right? It's better to have them plead to something negligently or recklessly than to have them plead to an attempt to do something recklessly, because that attempt language will be construed by immigration authorities as doing something intentionally or knowingly because they attempted to do it. So avoid the attempt language. Here's a quick example. Instead of pleading them to attempted child abuse, for example, as a class B misdemeanor, if you're coming down, attempted, you want to get down as low as you can on a child abuse, but if you can avoid the attempt language, and it would be better to do negligent child abuse, reckless is better than attempted, but if you can get to negligent child abuse, then that's the best of those three options. So don't use attempt language. Continue with aggravated felonies. So I've kind of broken it down into four categories of aggravated felonies. There's aggravated felonies that are based on the sentence imposed, okay? And it's typically a year or more of incarceration. So you can have, for example, theft. Class B misdemeanor theft is not an aggravated felony, but third-degree felony theft is an aggravated felony, right? And in the state of Utah, Class A misdemeanors used to be 365 days of maximum potential jail time on a Class A. A few years ago, they moved it down to they changed the statute and said that 364 days is the maximum amount of jail time for a Class A misdemeanor. Part of the reason they did that was because before, you had to be really careful pleading someone out to a Class A misdemeanor, and you would ask the judge, can you make sure that the sentence is 364 days or 360 days jail suspended, right? And they had to put that into the docket, into the language of the sentence to avoid this becoming an aggravated felony. Well, now pleading someone to a Class A misdemeanor, because the maximum potential in the state of Utah for jail is 364 days automatically, we don't have to worry about that. But, we'll talk about this a little later, if you can make sure that the total potential jail that's imposed is 180 days or less, then that might even mitigate further the immigration consequences of that conviction. And we'll talk about that in a second. But so the crimes that are based on the sentence imposed that make them an aggravated felony, whoops, went back, are right there on this list, right? Theft, receipt of stolen property, burglary, racketeering, certain document counterfeiting offenses, things like that. A crime of violence is specifically defined of having the element of use or attempted use or threatened use of physical force against another person. So that would be assault, right? So a third-degree felony assault could be a aggravated felony. Now, there's been a lot of litigation around crime of violence. It's been found void for vagueness here in the 10th Circuit. The U.S. Supreme Court recently found that reckless assault in the state of Utah, reckless assault in the entire United States, reckless assault is not a crime of violence, right? Because you have to show that there was, the use of force against another person, and our language for our assault statute kind of falls outside of that. But always be careful about felonies, obviously, but the amount of time that's imposed on a felony. So if a CIMT is punishable by a year or more of incarceration, that'll make it a felony. I mean, an aggravated felony. Another category are those that are based on the generic offense, right? Murder, rape, sexual abuse of a child, if you have a prostitution business, failure to appear. Those are listed as, just generic offenses that will be considered an aggravated felony. Now, failure to appear is very specific. If you're failing to appear to serve a sentence, if the underlying offense is punishable by a term of 5 years, or to face charges if the underlying sentence is punishable by 2 years or more. So not just any old failure to appear. And then there's the aggravated felonies that are described in certain federal statutes, controlled substance trafficking. And for trafficking, you actually have to have an exchange of drugs for money, right? There has to be remuneration there. Money laundering. I keep going back. Money laundering, child pornography, prostitution, espionage, alien smuggling, illegal reentry. So those are just deemed aggravated felonies, and certain firearm offenses. Now, interestingly enough, in the state of Utah, we allow people to plead guilty to antique firearms. Possession of antique firearms in certain jurisdictions in the United States, specifically the 9th Circuit, are not a firearm offense for immigration purposes. So that's one that you're going to want to consult with an immigration attorney about before pleading them to any kind of a firearm offense, and see if it's possible to do an antique firearm, and whether that will be useful for them, depending on the jurisdiction. And then the final category of aggravated felonies are those that are based on amount of loss, okay? So fraud charges, certain tax evasion charges. It's typically if the amount of loss was $10,000 or more, that was caused by the fraud or the deceit or something like that, or the forgery or whatever, then that triggers the aggravated felony consequences. And so many times we have pled somebody and specified in the charging documents and in the information and in the plea documents and so forth that it was less than $10,000, right? Maybe a specific number, 8,000 or whatever, to keep them out of the aggravated felony range. So I think that's all on aggravated felonies. So we've talked about CIMTs, we've talked about aggravated felonies. There are other just common deportation grounds outside of those two categories of CIMTs and aggravated felonies. One of those is drug offenses, okay? Possession of a controlled substance in the United States for immigration, I mean, it's just as bad as some of these aggravated felonies, right? I mean, it's really detrimental. So, interestingly, though, possession of less than 30 grams of marijuana for personal use and not for sale, not for remuneration, you can have one of those and still not be deportable, okay? But if it's more than 30 grams, or if it's for sale or anything like that, right, you don't get that one-time exception for, and it's only for possession of less than 30 grams of marijuana for personal use. But if you do have that conviction for less than 30 grams of marijuana for personal use, that still could make you inadmissible. You might not make you deportable, but it would make you inadmissible. So in Utah, what we have done is we've looked through all of the controlled substances in our schedules in the state schedule and compared them with all with the federal schedules. And there is at least one that we found, controlled substance that is a crime in the state of Utah, but is not a crime federally, and that is HU-211 spice. And so often we've advised non-citizens, if they have to plead to a controlled substance, to clarify in their plea form, and maybe even we need to change the information or the charging document to state that this was HU-211 spice. And then we can make that argument in front of the immigration judge that, Your Honor, this is not a controlled substance offense. Does not make them deportable because this was not on the federal schedule of controlled substances. Okay. And then paraphernalia. Possession of drug paraphernalia has been found to not be a controlled substance offense because you can have a sock or an apple. And those are paraphernalia, technically. But because they cannot be associated directly to a controlled substance on the federal schedule of controlled substances, it's not a controlled substance offense, possession of paraphernalia. All right, moving on. Domestic violence and stalking is another category that would make someone deportable if they're convicted of a domestic violence offense, but it's not just any domestic violence offense. It has to be a crime of violence as defined in federal statute. It has to fall under a crime of violence and be committed against a cohabitant. So it has to have the DV assault, but that specific assault has to fall under the definition of crime of violence. And like I said earlier, the U.S. Supreme Court in 2021, in the Borden decision, Borden v. U.S., determined that a reckless assault is not a crime of violence, even if it is committed against a cohabitant. And so there was actually a period of a couple of years there before 2021 when the 10th Circuit found that Class B misdemeanor DV assault in the state of Utah was a crime of violence and therefore a crime of domestic violence and deportable. And we had several clients who were in immigration proceedings and were barred from applying for their form of relief, being able to stay in the United States, because they just happened to be in front of the immigration judge during that time when DV assault was a domestic violence crime and a deportable crime in the state of Utah. But then after the Borden decision came out, all those who had delayed their deportation, we had appealed their decision. All of those are back in front of the immigration judge and able to say, that's not a deportable offense. It's not a domestic violence crime, because reckless assault currently in the state of Utah, so a DV Class B misdemeanor assault, is not a crime of violence and is not a deportable offense currently. We'll see how long this lasts. But in general, if there is a DV offense, you want to avoid assault. Disorderly conduct is a good option. Criminal mischief is interruption of communication device, even threat of violence. Do not meet that definition of crime of violence because there's not a use of force against another. And so those are okay. But if you can drop the DV tag, even better, right? But otherwise, you do want to clarify that there was no physical contact, no unwanted touching of another person, okay? And just to note, DV in the presence of a child, because there's no contact, is not a domestic violence offense. Stalking, you want to avoid that one, okay? Violation of a protective order. There is specific language in the Immigration Nationality Act which tells you what a violation of protective order is, and actually specifically what aspects of a protective order needed to be violated in order to carry those negative immigration consequences, right? And it specifically says, repeated harassment. So and things like that. I mean, there's language in there. And so we've done plea deals where we have specifically said this violation of protective order did not include, and then put in that language, repeated harassment. I don't have it off the top of my head, but there is language that you can put in there to kind of keep it outside of the realm of violation of protective order. Or violation of a jail release agreement in the state of Utah is a good alternative, because a jail release agreement does not fit the definition under federal law of a protective order. So there's another few tips for you as far as what to look for. Child abuse, I've already talked about this one. Child abuse convictions, can carry immigration consequences, but if you can go with negligence, a Class C misdemeanor, I think it is in the state of Utah, negligent child abuse, that would take it outside of the realm of a deportable offense of child abuse in the 10th Circuit. And then I'm putting in here again, DUI is not a deportable or an inadmissible offense because it's a strict liability offense. It's not, a Class B misdemeanor specifically does not carry those immigration consequences. Now, depending on the facts of the DUI, the type of immigration benefits sought by the defendant, their past immigration history, the priorities of the federal administration at the time, a DUI can carry negative immigration consequences and even lead to deportation, mainly and usually just by the fact that if they go to jail, if they step inside the jail and they take their fingerprints, everyone who is booked into jail, not on a book and release, but is booked into jail, ICE is alerted to those people. And then ICE will do a quick check of their background and find out if they are deportable, what the offense is, and things like that. Not necessarily because of the DUI will they put an ICE hold on them, but simply because the DUI got them to the jail, and then they find out, oh, well, this person is deportable for other reasons. And it could be just because they're in the United States without documentation, and the current administration at the time says, hey, if you've got a DUI, we're going to pursue deportation against you. That's a priority that they decide on. And those priorities change with each administration. Under the current administration, under President Biden, having a DUI is not a priority, doesn't make you a priority for removal. And so we've had a lot of folks in these last couple of years who've gotten a DUI, they've gone to jail for it, but then even after they finish their jail term, ICE knows about them, knows that they have a DUI, and says, well, they're not a priority for removal, and lets them get out of jail and remain in the United States. If you have a DUI that's based on alcohol, that is safer than a DUI that's based on drugs or driving with a measure controlled substance, because driving with a measure controlled substance can be considered a controlled substance offense, and a controlled substance offense is deportable, right? And so leave it ambiguous, and the assumption is that it's based on alcohol. Or if it is very clearly driving with a measurable controlled substance, you might want to delineate what the controlled substance was, specifically HU-211 spice, and see if that can get them out of the deportability realm. And then, like I said before, a DUI can cause problems if they're here just on a visa, on a tourist visa or something like that. That can cause problems with their visa, and it can delay their ability of a permanent resident to apply for U.S. citizenship. Okay. So that was all deportability. So far, we've just been talking about deportable offenses. Common grounds of inadmissibility, there's a lot of overlap between deportable offenses and inadmissibility. Offenses that make you inadmissible, right? CIMTs, for example, can make you deportable. They can also make you inadmissible. Now, under the inadmissibility statutes, it does say that you get one petty offense exception for a single CIMT. So, but very specifically, the maximum potential penalty has to be less than a year, and then the actual sentence, if there was any time imposed in jail, has to be 6 months or less in order to fall under this petty offense exception, okay, for a CIMT. And that will only keep them out of, it'll help them to fall under that petty offense exception and not be inadmissible. So, for example, if they have to plead to a CIMT, this is the only time when a plea in abeyance might be useful for a non-citizen, because if it's a Class A misdemeanor, for example, and they did a plea in abeyance to a theft charge as a Class A, okay, that's a CIMT. But because there was no jail time imposed, they do the plea in abeyance, the judge holds the plea on the shelf for the 12 months or whatever it is, they comply, they never screw up and have an order to show cause, and it gets dismissed. It is still a conviction for immigration purposes, but because there was no jail time imposed or suspended or anything on a plea in abeyance, that CIMT can fall under the petty offense exception, because the maximum potential was 364 days, and they were sentenced to 6 months or less. In this case, none, right, on a plea in abeyance. Or just go with a Class B misdemeanor, because the maximum penalty on a Class B misdemeanor is 180 days. So those two could fall under the petty offense exception for inadmissibility if they have to plead to a CIMT, okay? Other things that make you inadmissible: multiple convictions, where if you add all the potential sentences together and it's more than 5 years, right, that will make you inadmissible. If you've engaged in prostitution within 10 years, or have anything to do with prostitution, that will also make you inadmissible. All right, we're to the end. We're kind of coming up on time. So the last thing I want to talk about real quick is what to do when there is a conviction. First of all, refer them to an immigration attorney or crimmigration attorney, because not all hope is, all hope is not lost, okay? There are certain things that can be done to get rid of a conviction, but it's very specific. Matter of Thomas and Thompson is a decision directly from the Attorney General, Bill Barr, in 2019, stating that whatever you do in state courts to try and reduce or alter or change or even vacate a conviction, a state criminal conviction, will not be recognized by the federal government as mitigating immigration consequences, unless there's only one way to get around that. Unless you can show that whatever you did in the state court to change the conviction was based on a procedural or substantive due process defect in the underlying criminal proceeding, okay? And so under our new 402 reduction statute, 402 reductions are not helpful. They're not gonna meet that standard. But if you were to vacate or reopen and strike a plea based on, and this is the one that we almost always rely on, ineffective assistance of counsel. Ineffective assistance of counsel is a procedural or substantive defect in the underlying criminal case. And if that ineffective assistance of counsel happened to be after 2010, and it's based on the fact that, the prior defense attorney did not properly advise them of their immigration consequences, that counts. We typically use Rule 60b-6 of the Utah Rules of Civil Procedure, saying that this is, not in the interest of justice, and Mesa v. State, and I've got the reference there, which says you can do that on, even on plea and abeyances that have been dismissed. You can still reopen the plea and abeyance, strike the plea, and if it's based on ineffective assistance of counsel, that will be recognized by immigration. Or you can go with the Post-Conviction Relief Act, right? Which is very limited and when and how you can do that. But if you can do that based on ineffective assistance of counsel, that would be recognized by immigration as changing the actual conviction. So those, that's a very brief overview. And if your head's hurting or you feel like you've been drinking out of a fire hose, welcome to our life as crimmigration attorneys. But I've left my information up here. If you have questions, you can reach out to me. You can reach out to Adam Craik or Joe Johnson in my office. They are also very well versed in crimmigration. Or find a local crimmigration or immigration attorney who you can refer your clients to, or you can call on the phone. But make sure you find out beforehand whether or not your client is a U.S. citizen or not before they enter a guilty plea. Pam, do we have any questions?
It does not look like we have any questions in the chat. I did want to ask based on this. It's really complicated and a lot of things going on, a lot of moving pieces. If there's a lawyer who's wanting to get more experience in this and wanting to learn more about it so he can be more effective, what's the best way to do it?
Oh boy, that's really tough. I would say that the best way to do it is to connect with an immigration attorney, a crimmigration attorney that already has that experience, because I've looked to find, there are some resources put out by the American Immigration Lawyers Association, or AILA. There's books, there's things like that, but really the best way, because immigration law is constantly changing, and is to, have that somebody that you can call and rely on, right? Ask them questions. There are some listservs, there's things like that, but it is a case-by-case basis, and so you really need to have somebody who's experienced look at it.
Yeah, that makes sense.
There's some other chats. Let's see.
It looks like there is a question. Oh, it just disappeared from my screen. Hold on.
Let's see, would a Class B misdemeanor property destruction with a DV tag count as a CIMT? Property destruction or criminal mischief is generally not. Okay. Seeing if there's any others. Slides will be made available. They're going to turn them into a PDF and send those out, I think. Payment of a fine, specifically bail forfeiture. Bail forfeiture is not a conviction. Okay. Payment of a fine is a penalty, and if there is a guilty plea associated with it or an admission of guilt associated with it, that would make it a conviction. But the question was, is payment of a fine not a conviction? No, it's not the payment of the fine that's not a conviction. Bail forfeiture, where you don't go in front of a judge and you don't admit guilt. There was no admission of guilt. You just paid a ticket, right? And it ended up saying on the docket bail forfeiture, not a conviction. So I think that's all the questions. Anything else?
It looks like there's one more. Are all DV in the presence of a child deportable? How to pitch to avoid?
No, so DV in the presence of a child all by itself, and that's important, all by itself is not a deportable offense. At least there's the argument that it's not a deportable offense. But generally prosecutors are like, I'm not going to let you plead to just DV in the presence of a child without actually pleading to the offense that you committed, the DV offense that you committed. If they're willing to do that, that's much better, right? I mean, you want to take the DV in the presence of a child and avoid the other charge, the DV assault or whatever it was, right? If you can do that. So let's see. And then we say, but if you pay the fine, is a guilty plea. So yes, I mean, I'm differentiating between paying a fine and paying and doing bail forfeiture, which is, I mean, it is a fine, but there is no admission of guilt when you do a bail forfeiture. So that's the difference. Any arrest is a negative factor on the discretionary matter for immigration purposes. Yes, yeah, I mean, just having the arrest can be considered, especially by USCIS, they can look into it. They can look into an arrest, okay? But it is not a conviction. An arrest is not a conviction that carries the deportability or inadmissibility grounds per se. So, all right.
I think that's time. Thank you so much, everyone, to our presenters. This was wonderful. Thank you for the excellent information. Have a good afternoon, everyone.
Bye.